So he said, having you conceal the son from him. I'm doing a continuation because the timer cut the video off. She didn't have to answer that question. She also lied under oath, perjury. I don't know if I stated this before, but I'll state it again. I don't know if I stated it in the first video, but under oath, she stated that he only had visitation. And guess what? See, the reason why they coached her. They was coaching her, to lie. The state always lies, basically, But so she said they didn't have joint custody. Now, this criminal complaint, and the man pointed this out, and the judge told him the criminal complaint didn't matter. It was hearsay. Right. So, why at this preliminary hearing that the man did not waive, that the state had the burden of proving the elements of the felony charge of interfering with custody beyond visitation, it says this criminal complaint, which was signed by Assistant District Attorney Peter Templess, it was sworn to under oath. Criminal complaint says your complainant reviewed a copy of a document entitled Findings of Fact, Conclusion of Law, and Judgment of Paternity. A copy of a document involving the woman and the man, and read the paternity of the child, and it was provided by the woman. So now, under oath, she said he didn't have any custody of her child, but you have a criminal complaint that was sworn to that says the woman provided the police with a copy of a judgment of paternity order that said, and it was signed November 21st, 2007, and orders that the father shall have periods of physical placement. Periods doesn't define the periods. Doesn't say 12 hours. Doesn't say 10 hours. Said periods. Define period. A time. Of the child at reasonable times upon reasonable notice. The document further orders that custody shall be with parties jointly. Under oath, she perjured herself. There is no custody order giving him 12 hours of visitation. Didn't even say anything about visitation. And I know a number of cases in Milwaukee County Courthouse, and I still know the names of the parties, in which the state has given people so-called victim money to hush them up, to lie. And there's a woman working in Milwaukee County Courthouse right now who knew she lied on the man, and they gave her a job. As God is my witness, just so happened I saw the woman walking through the courthouse today. as I was talking with the man after the court proceedings. And then the sheriff deputy had the nerve to tell me when I asked for transcripts of the proceedings, I wanted to make arrangements to order the transcripts. He told me I couldn't make arrangements to order transcripts. That's what he said. That's what he claimed. Of course, I know otherwise. But fear, as Tupac Shakur once said, is stronger than love. And what I saw today was a fear of the truth coming out. And I saw judicial misconduct. I saw perjury. I saw prosecutorial misconduct. And I saw that man, a victim, being further victimized. And children who should be protected aren't. And yes, the little boy will be called as a witness, who loves his dad. And this man has a right to call this boy as a witness, young boy as a witness. And other witnesses will be called. And there again will be concrete proof. Milwaukee County Courthouse is a criminal enterprise that the judges routinely violate the oath that should be taken, which their oath has been altered. And this man is facing over 20 years. And, you know, I've been listening to a lot of black men telling me a lot of stories, you know, heart-wrenching stories that really has me looking through their eyes. And I saw so many cases today in this courtroom in which there was no evidence of battery. You know, and that circuit court judge, Ellen Bromstrom, in that case with the little girl, she made a statement. I have it on my notes about men abusing women, and this man and the mother of the child. See, they didn't bring photos either. The DA was just, oh, this baby had he whooped the baby with a belt, the girl with a belt. She was like 7 or 8, and the mother said, hey, no, this didn't happen. And the mother was pointing stuff out. The mother was pregnant, because the DA thought the mother was going to get on there and be on his side. That mother broke it down. And even though she told the facts and pointed out where the inconsistencies were and how the judge could find it, organized crime was in that courtroom. And so there is no official, even an unofficial, copy of a paternity judgment order attached to this criminal complaint. It is hearsay. It is falsely sworn to. But they attach a copy of a printout of